this video, we'll look at the differences between two legal systems, namely the common law system and the civil law system. You'll actually study this in law school, but I'm giving you a synopsis here because I believe that it helps you understand many things that are important to lawyers. To understand how the common law and civil law traditions are different, we must first ask, how is law made and who makes the law? This video helps us find answers to many questions, including why we refer to judgments for the law if under the doctrine of separation of powers, the legislator or the parliament makes the laws. So why do we give judges this unique power of case law? The answer lies in the method in which the common law system works. Under the common law system, which is followed in many countries in the world, there is a recognition of the concept of judge-made law. In this legal tradition, although the parliament or legislator makes the laws, the judges in courts are given a power to make the laws as well, and the judgments of the courts become binding laws of the land. Now, the common law system has its roots in 12th century England, where initially the law was made only by judges. Subsequently, the system evolved to its form today, which is basically where both the parliament and judges make the binding law, and the judges follow the decisions of other judges in previous cases. And when England colonized many countries of the world, they supplanted their legal system there. And this is the reason why the common law system, that is, where judges have the power of making and shaping the law in addition to interpreting it, is found not only in the UK, but also in India, USA, Canada, Australia, and the other former colonies of the UK. If you want an example of how judges can make law, you only have to refer to the law of torts. There is no statute or act like the Indian Torts Act passed by the parliament that governs torts or private wrongs. Then how is the field of torts regulated? The answer is that the courts have given judgments on torts or private wrongs for hundreds of years, and if we wish to learn the law related to torts in India, we studied from the judgments of these cases because they are case law or judge-made law for the field of torts. Now, common law is based on the concept of judicial precedent, and these are all important terms that I want you to pay attention to. Judicial precedent basically means that the judgment in the previous case is binding law and the subsequent judge refers to it as a binding law. It doesn't mean that the whole judgment as a whole is binding law, however. Only that part of the judgment which relates to the application and interpretation of the legal principles to the facts becomes binding law in the field. And this part of the judgment, which is the binding law in the field, is called ratio decidendi or simply ratio, which is basically the rationale or logic which is underlying the interpretation or the application of the law by the judge. For instance, in a case related to the validity of a Hindu marriage, in a case where the groom was 20 years of age, the judge can hold that under Section 5 of the Hindu Marriage Act, a valid marriage requires the groom to be about 21 years of age. And since the groom was under 21 years of age in this case, the marriage is not valid. So after this judgment is passed, what effectively happens is that when another case of similar facts comes across the court, where a man under 21 years of age marries, this case will be cited by another judge to hold that the marriage is not valid. This can be contrasted with other parts of the judgment, which are called as obiter dicta or simply obiter. Judges might make many comments in the judgment which are not related to the application or the interpretation of the law. For instance, maybe the judge in the earlier case makes comments on marriage, something like, there is an increasing trend of people getting married at an early age. Youngsters are falling in love and eloping because they are influenced by Western culture. The government must immediately ban Hollywood movies and English TV shows, and government must increase their budget on education so that youngsters are guided in the right path. These are all personal comments of the judge, which can be distinguished from the actual application and interpretation of law to arrive at the judgment of the case. And these extra lines or comments are called obiter. And you can see that Western shows being banned and government spending on education being increased are not going to be binding law because they're merely obiter and comments and not the ratio of the judgment. But why does this case law method work? You might find it very logical actually. A fundamental principle in the working of law is that law must be known to everyone and it must be certain. It must be enforced in the same way against all people in all situations. Let's take the earlier example of a Hindu marriage where the groom is 20 years of age. What if one judge in one case holds it to be an invalid marriage and later a different judge or even the same judge holds a similar marriage to be valid? Don't you think there'll be a lot of confusion and chaos when people do not know what is legal and illegal? People would not know what they're allowed to do and what they're not allowed to do. The case law system is essentially a check against this, and this is based on the doctrine of stare decisis, which means let the earlier decision prevail and don't change it. Where essentially you're asking the judges to respect what already has been held and continue with the same kind of judgments so that people would know what the law is and how it will be interpreted by the courts. So finally they can better regulate their behavior. Sometimes, of course, some judges might not want to agree with the previous case. And in that case, the judgment can overturn the previous judgment through their new judgment. But the point is that they cannot ignore a previous judgment and pass their own judgment irrespective. They must acknowledge the previous judgment and state the reasons for disagreement and then state that so-and-so case is being overturned. Let us now look at civil law. Civil law does not give judges the same kind of pass. Here, when the legislators pass the law, it is the primary law of the land. This codified or written law has the final authority as law. The judges do not have pass to make law, and case law is subordinate to the written or codified law made by the parliament. Examples of such countries are European countries, except UK of course, like France, Italy, and further east we have China, Japan, etc. Although common law is called common, we find that civil law is far more common in the world. There are about 150 civil law countries, but only 80 common law countries. One other point regarding this that I want to raise is that since the legal systems are the same in common law countries, the law degree that you will study in India is actually valid in UK, USA, etc., where you only have to write the bar exam to practice there. You need not study an additional law degree if you want to practice there. However, since civil law systems work differently, if you were to settle in France, Japan, etc., you would need to study a law degree there again before you can practice. So it is not true that lawyers do not have international opportunities. We actually have plenty of options to choose from. Finally, some people ask which one of the two systems is better. I think this is a very juvenile question considering that these systems have been in place for hundreds of years and they're working out just fine for the respective countries. We will actually see that these systems offer some very specific advantages in some circumstances. Civil law proponents might say that they like their system because the law is clear and they do not have to worry about it changing suddenly because of some one judge in one case. The law is always clear and it's very easy to discern and has no ambiguities. However, common law citizens might like their law exactly for this flexibility that it offers. Common law allows for contingencies and new circumstances in the society which might require a change in the law. And the law can be adapted quite easily in the common law system by the judges through a simple act of delivering a judgment, instead of the people having to run to the legislators and wait until the legislators actually change the law. So I hope that now you appreciate the differences between the common law and civil law. From now, whenever we discuss cases, remember that they are relevant to us because they are judge-made law and India is a common law country where this case law is binding. Finally, remember that the higher the court, the more precedential value its judgment has. So the Supreme Court's judgments are binding on all lower courts of the land.